My name is Emily and I am here with Maya Murphy's attorney, Eva Marie Franco-Fox. Attorney Fox practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is financial disclosure required for a prenup or postnup in Connecticut? And if so, what kind of disclosure?
In Connecticut, parties to a prenuptial or postnuptial agreement are required to engage in financial disclosure. This is to ensure that neither party is later in a position to say, I didn't understand what my rights and obligations were at the time I signed the agreement, or I didn't understand what I was waiving or agreeing to because I didn't have a full understanding of the financial consequences or circumstances. So Connecticut law requires what's called fair and reasonable financial disclosure. I know that sounds vague. So what does that mean? Fair and reasonable financial disclosure in Connecticut means that each party must provide a, quote, general approximation of their respective income, assets, and liabilities. This does not mean that the financial disclosure needs to be accurate or precise down to the penny. The courts understand that bank accounts, investment accounts, or even the fair market value of certain assets may fluctuate from month to month, week to week, and day to day. And so the court is not going to determine that financial disclosure is insufficient if it's a penny off, or if it changed from day to day. However, the courts want to ensure that each party has a complete understanding of the amount, character, and value of any property, of any income, or any other financial obligations of each of the parties. And so what is sufficient to determine or to give an understanding of the amount, character, and value of property, income, and liabilities can vary from case to case, and it's very fact-specific inquiry. And certainly if financial disclosure is challenged, the court will look at what was actually disclosed and what the actual value and nature of the estate was at the time of disclosure to determine what are the discrepancies. And that may vary from case to case. And so certainly it depends on what the specific circumstances of your case are as to whether or not the financial disclosure was sufficient. Now, it's important for parties to know that in Connecticut, the duty is on the party to disclose, not on the party to inquire. What does this mean? This means that it's not a defense to say, well, I didn't disclose my assets or I didn't disclose my income because they didn't ask me to, or they didn't ask about that specific asset. It's on the burden on the party to provide documentation, not on the party to ask about it. Now, if financial disclosure is insufficient, it's possible that a court in Connecticut can invalidate your whole agreement or at minimum certain parts of your agreement. So the financial disclosure component is very important to ensure that it's done properly and it's done accurately. And so in the event that you are negotiating a prenuptial or postnuptial agreement, it's critical to consult with an attorney to ensure that you're in compliance so that your agreement is not later invalidated on the basis of a challenge to the financial disclosure.